Folks, a crucial U.S. Supreme Court case or arguments took place today that deals with the possibility of adding a new black congressional district in Alabama. The challenge was with regards to the Voting Rights Act. The Supreme Court previously has curtailed the Voting Rights Act, namely Section 5. Now, this particular case today deals with Section 2. Conservatives hold a 63 majority on the Supreme Court, and the issue of race was front and center in today's court hearing. We've heard from Justices Alito, Coney Barrett, Clarence Thomas said little. Justice Neil Gorsuch didn't say much at all, but it also was a debut of new Supreme Court Justice Ketanji Brown Jackson, and it did not take long for her to assert herself and to show her expertise on the court, especially regarding this case and the history of the 14th Amendment.
I don't think we can assume that just because race is taken into account, that necessarily creates an equal protection problem, because I understood that we looked at the history and traditions of the Constitution, at what the framers and the founders thought about. And when I drilled down to that level of analysis, it became clear to me that the framers themselves adopted the Equal Protection Clause, the 14th Amendment, the 15th Amendment in a race-conscious way. That they were, in fact, trying to ensure that people who had been discriminated against, the freedmen, during the Reconstruction period, were actually brought equal to everyone else in the society. So I looked at the report that was submitted by the Joint Committee on Reconstruction, which drafted the 14th Amendment. And that report says that the entire point of the amendment was to secure rights of the freed former slaves. The legislator who introduced that amendment said that, quote, unless the Constitution should restrain them, those states will all, I fear, keep up this discrimination and crush to death the hated freedmen. That's not a race-neutral or race-blind idea in terms of the remedy. And even more than that, I don't think that the historical record establishes that the founders believed that race neutrality or race blindness was required, right? They drafted the Civil Rights Act of 1866, which specifically stated that citizens would have the same civil rights as enjoyed by white citizens. That's the point of that act, to make sure that the other citizens, the black citizens, would have the same as the white citizens. So they recognized that there was unequal treatment, that people based on their race were being treated unequally. And importantly, when there was a concern that the Civil Rights Act wouldn't have a constitutional foundation, that's when the 14th Amendment came into play. It was drafted to give a foundational, a constitutional foundation for a piece of legislation that was designed to make people who had less opportunity and less rights equal to white citizens. So with that as the framing in the background, I'm trying to understand your position that Section 2, which by its plain text is doing that same thing, is saying you need to identify people in this community who have less opportunity and less ability to participate and ensure that that's remedied, right? It's a race-conscious effort, as you have indicated. I'm trying to understand why that violates the 14th Amendment, given the history and background of the 14th Amendment.
Supreme Court Justice Elena Kagan, one of the liberal members of the court, talked about the precedent of the Supreme Court in previous voting rights cases.
You know, this is an important statute. It's one of the great achievements of American democracy, to achieve equal political opportunities regardless of race, to ensure that African Americans could have as much political power as white Americans could. That's a pretty big deal, and it was strengthened, this statute, in 1982 when this court interpreted it too narrowly for Congress's taste. And Congress said, no, we didn't mean that at all, and made this into a results test. Now, in recent years, this statute has fared not well in this court. Shelby County looks at Section 5, and it says, no, Section 5 We don't need that anymore. And one of the things it says is we have Section 2. And then Brnovich comes along, and that's a Section 2 case. And the court says, you know what, Section 2, they're really dilution claims. This is a denial claim. And so we can construe that very narrowly. But of course, there's just all these cases that are dilution claims. That's really what Section 2 is about. And now here we are, Section 2 is a dilution claim. This, the classic Section 2 dilution claim. And you're asking us essentially to cut back substantially on our 40 years of precedent and to make this too extremely difficult to prevail on. So what's left?
All right, folks, that was Supreme Court Justice Elena Kagan. Now, remember, Alabama was defending this law. Here's some of what was stated by the defense.
They argued that Section 2 of the Voting Rights Act requires Alabama to replace its map with a racially gerrymandered plan, maximizing the number of majority-minority districts. But Section 2 requires an electoral process equally open to all, not one that guarantees maximum political success for some over others. Section 2 does not and cannot obligate Alabama to abandon district lines enveloping the undisputed, long-standing community of interest in the Gulf to be replaced by district lines dividing black and white with such racial precision that Alabama could never have constitutionally drawn those lines in the first place. Yet that is what Alabama has been commanded to do here, redraw its districts to subordinate traditional districting principles to race. The only way to add a second majority-minority district to Alabama's plan is to make race the non-negotiable criterion. Plaintiffs' illustrative plans prove the point. They offer only one way to get that second majority black district: split Mobile County and divide the Gulf by race. Their new versions of Districts 1 and 2 then stretch the width of the state to group together black voters from disparate areas as far west as Mobile and as far east as the Georgia border. The district court relied on these outlier plans to invalidate the state's neutrally drawn map, and that was legal error. Requiring states to scrap neutral plans in favor of plans drawn on account of race sets Section 2 at war with itself and with the Constitution. The court should make clear that if a state's plan is the product of the state's neutral districting principles, the plan is equally open to all voters. Because Alabama's 2021 plan is such a plan, plaintiffs' claims fail. I welcome the court's questions.
What would you use as a comparator? I assume that your problem is that the comparator here was had race as non-negotiable. What would you use as a comparator, even if you thought that there might be some vote dilution problems with your plan?
I think the plan that would be the adequate comparator would be one that respects all of our traditional districting principles as much as our own map, but then has some different sort of racial outcome, similar to what the court has proposed in Cromartie 2, for example. That sort of map can actually show that there's a problem with our map. But if you are discriminating in favor of one racial group, then that map cannot show that our map was discriminating against that group. It's a flawed control.
Well, don't you think there's an overall problem with, in these dilution cases, of determining at the beginning what the comparator should be?
Yes, Your Honor. I think, as this court noted, both in the Holder v. Hall plurality and in Brnovich, benchmarks are critical in any Section 2 case. And we've proposed a benchmark to the court. Plaintiffs have not proposed any benchmark other than perhaps maximization or proportionality. But, of course, Section 2 rejects a proportionality baseline, and this court has wisely rejected maximization and proportionality because they lead to constitutional problems.
Do you agree that the benchmark you propose has never been recognized by this court as the benchmark that's appropriate in these kinds of cases?
I don't think so, Justice Kagan. First, I mean, going back to Jingles, I think the benchmark there, even for multi-member districts, was neutrally drawn single-member districts, not racially gerrymandered single-member districts. And when you continue—
Of course, you're requiring that there be that kind of benchmark. The question is not whether it's permissible. You are requiring that there be a race-neutral benchmark. And I'm asking whether that requirement has ever been stated in our precedents.
I think that's what Bush v. Vera, what Abrams, and what LULAC were all pushing towards when they said you must account for traditional districting principles. I don't know why you would even account for them, except that if a plaintiff's failure to account for them in their map, if plaintiffs fail to account for them in their map, then their map can't really shed any light on whether there's a problem.
I ask because what strikes me about this case is that under our precedent, it's kind of a slam dunk. If you just take our existing precedent the way it is, and the three judges below all found this. The three judges below said, this is an easy case. It's not one of the hard ones. It's not one of the boundary line cases. It was clear that the plaintiff satisfied the Jingo's preconditions. And past that, you're looking at a state where there are 27% of the population is African American, but only one of 7 districts, where there is incredible racially polarized voting, where there is a long history of racial discrimination in the state. Put all that together, and it seems clear that under our existing precedents, the inquiry is complete in just the way that the court below found. And, it seems to me that you're coming here, and it's totally your right to do it, but really saying change the way we look at Section 2 and its application.
All right, folks, back to that Roland Mark Unfiltered video in just one moment.
When we invest in ourselves, we're investing in what's next for all of us. Growing, creating, making moves that move us all forward. Together, we are Black beyond measure.
Folks, Black Star Network is here.
Hold no punches.
I'm real revolutionary right now.
Support this man, Black Media. He makes sure that our stories are told.
Thank you for being the voice of Black America, Roland.
Stay black. I love y'all.
All momentum we have now, we have to keep this going.
The video looks phenomenal.
See, there's a difference between Black Star Network and Black-owned media and something like CNN.
You can't be Black-owned media and be scared.
It's time to be smart.
Bring your eyeballs home.
You dig?